Jai Bhim, Jai Mulyavasi, Jai Savidhan, Jai Bharat. Welcome you all to MNT News Network's special primetime session. Today is Sunday, and all of you know that every Sunday we are organizing the discussions specifically in English so that it will cater our South Indian mass as well as the NRIs. And we are discussing various topics that are related to the marginalized section, specifically the scheduled caste, scheduled tribe, other backward classes, and the minorities, which are very, very important topics and important developments are going on in the field. So every Sunday we are taking various issues, and today also we are going to discuss on very, very important topic which had recently happened, and Supreme Court has given the judgment on EWS reservation. So as far as the overall development has happened, we are going to discuss this particular topic. So considering the importance of the topic, I would request all the viewers to share this link on their personal Facebook timeline so that every others on their network will get a link, get a notification of this important video, important information. Also, all the viewers who have joined through Facebook, they are requested to share this particular information, like, comment, so that all the people who are there in the network will get a notification, and they can also join this important session and will enlighten with the current situation, what's going on related to EWS reservation, and how the development has happened and what can be its short-term and long-term impact. So very, very important topic. And today we have with us a very eminent personality, Mulyavasi Professor Dr. K. Elumalai sir had joined along with us. He is advocate in Supreme Court of India and a former professor of law in the Central University. And he was a direct person who was involved during all the development in the Supreme Court. So we will get the first-hand information. So this is once again appeal to all the viewers to like, comment, and share this particular video and pass the link of this particular video to all the viewers. This is a very, very important topic: long-term impact of Supreme Court judgment on the EWS reservation. So, considering the importance, once again, I am requesting each and everyone to share this link so that they will also be a part of this important discussion. So, without wasting time, I would like to invite Dr. K. Elumalai sir to our MNT Network studio. Sir, good evening, sir. Welcome to MNT Network. Jai Mulyavasi, Jai Savidhan, Jai Bharat.
Thank you.
Thank you very much for sparing your valuable time with us once again.
Yes,
and today also we are going to continue the same topic last time what we discussed. So before we move forward, I would like to know from you and to our viewers also regarding this overall development till the reservation notification, till the reservation result had came on this particular EWS reservation. So in brief, first we would like to know what exactly was the judgment. And then after that, we would like to hear, since you were directly involved right from the beginning of this particular 103rd amendment. So we would like to know from you how these developments had happened and how it is correlated with all the developments, with all the pillars of the democracy and all. We basically try to correlate this particular issue with the important functionaries of the democracy of India, sir. Please, sir.
Yeah. So your question is very relevant that you want me to speak about the judgment on the EWS delivered by the Supreme Court of India on 7th November by a 5-judge bench. Now, in order to understand the judgment clearly, we should also know what is the reason or basis or issues on which the Supreme Court was asked to deliberate upon the issue and deliver the judgment. And for that purpose, we should also know what is the root cause or the basis or the purpose for which the matters came before the Supreme Court. So to begin with, let me tell you very briefly, the Parliament, by way of 124th bill, introduced a 10% reservation for economically weaker sections of the society for admission into central government institutions, including aided and unaided institutions, excluding institutions covered under Article 30 of the Constitution. That is one type of reservation provided for the economically weaker sections, about which we will discuss it later. And B, another reservation was made is also 10% reservation, that is up to 10% in jobs in the government, in the governments. So these are the two reservations made by way of the 104th Amendment Bill, which ultimately came as a 103rd Amendment Act 2019. Now, these are the things. These provisions of making reservation for a new class called the EWS, economically weaker section. This is the new term coined by the present government. It is not. This term is not found, to the best of my knowledge, in the either in the constitutional debate or elsewhere. That's about it. Now, in order to arrive at a decision on this aspect, the Supreme Court of India, we made three issues broadly to understand this. First is, the issue framed was the reservation. This is, before that, what is the petitioners, like we, made the challenges before the court are three mainly. Number one, reservation in reservation in education and employment society on the basis of economic criteria alone, singularly, is impermissible and against the basic structure of the Constitution, about which I will briefly explain it later. The second challenge made was exclusion of socially and economically backward classes, that is, scheduled caste, scheduled tribes, and other backward classes, non-creamy layer, from the benefit of 10% reservation made for economically weaker section is discriminatory and destroy the basic structure. Second issue. And the third issue is provision of 10% additional reservation over and above 50% ceiling of reservation already settled by the Supreme Court in its decision in Indira Sani case, hence results in unacceptable abrogation of the Equality Code, which again destroy the basic structure of the Constitution. These are the three issues to sum up. So this Equality Code, it comes under Part 3 of the Constitution of India, Article 14 to 17, about which discussed later. Now, based on this issue, the Supreme Court gave its verdict. I will just say in the two parts. The overall operative portion of the judgment delivered, all put together. Then the the splitting of it. I'll tell you. The operative part of the judgment says that the challenges raised to the 103rd Amendment to the Constitution of India fails due to the majority rendered by 3 judges, and the remaining 2 judges gave the minority opinion. So in a nutshell, the Supreme Court held that the challenges, all the 3 challenges fails. That necessarily means what the bill, what is provided in the bill, that is making reservation of 10% in educational institutions and jobs, are perfectly valid and constitutionally acceptable. That is what the in a nutshell is. However, now there are 4 judgments have been delivered by independently, 3 for concurring and 2 for another minority opinion. Now, what is that important is the logic and reasons given by them should be very, very important. In law, we say justice not only done, it must appear to have been done. This is what simply justice. Anybody can give justice, but whether is it for a common man, it looks like a really justice delivered. If you ask me this, in my opinion, justice is not delivered in this. For a common man, it is the justice that doesn't appear to be delivered. Reasons are very many. We'll go about it. Now, what is that? Very briefly, the important. We are not, for today's discussion, the minority opinion judgment given by the Justice Ravindra, but we are not going to take it because that is not our for our discussion. So I will confine only to the judgment delivered by Justice Dinesh Maheshwari, along with other 2 other judges, Bella Trivedi and Judge Pardiwala. These are the 3 things only, about that only. The first issue, does economic criteria as a sole basis of violates the basic structure. That is the first issue. For that, Justice Mageshwari says that reservation structure based on singularly on economic criteria does not violate the essential feature of the Constitution and also does not damage the basic structure of the Constitution. On this, Justice Dinesh Mageshwari said it. On the issue two, exclusion of classes of SC, ST, and OBC from getting benefits of EWS affect the basic structure or not. For that also, he answered in a different manner that he says that the exclusion of SC, ST, OBC from the benefit of EWS is in the nature of balancing the requirement of non-discriminatory and non-compensatory discrimination. Hence, it does not violate the equality clause. And the third one on breaching of the 50% ceiling, he again says that EW reservation 10% does not result in violation of the essential features of the Constitution. This is what in a nutshell will be. Now, in all these places, we have come across about basic structure. For a common man, one should understand what is that basic structure is all about. I will not go in detail, but I would like to say that what are the very justly the basic structures identified by the under the case one on the bar, the case I would like to bring to notice of all. There are generally the basic structure principle enunciated by the famous the holy case one on the case. They have identified broadly 6 basic structures. Those are the supremacy of the Constitution is one of the basic structures that necessarily means that cannot be violated. The second basic structure is the Republican democratic form of government, which cannot be violated or which cannot be violated. Then separation of power between legislature, judicial, and executive. That power that cannot be affected, that cannot be destroyed. Then judicial review by the court under Article 32 and 220 of the Constitution of India. That's a very one of the essential features of the Constitution, the basic structure, though it cannot be affected or destroyed. And the fifth one is sovereignty and integrity of the nation. It is again the forming part of the basic structure, so it cannot be destroyed or amended or altered. And the last but not the least, federal form of character or federal character of the government. So this, not only this, there are very many evolutions will keep on coming as a basic structure, depending on the new developments taking place. So these are so just to conclude, all the petitioners, including ours, we challenge this on these 3 grounds that it affects the basic structure of this and why equality code under Article 14, 15, 16, 17. This is what I think. Now, with this is the judgment given by the Supreme Court on which we will discuss elaborately further. Over to you, please.
Yes, sir. So you have rightly pointed out that whatever the right from the beginning of the implementation of Constitution, if we see 1950 onwards, the most of the Supreme Court judgments had came up against the reservation, means not implementing the reservation. From that point of view, most of the cases were raised. But now, if we see the developments toward the 103rd Amendment, it seems that means the developments are happening in such a and so fast way in a day or two, and even the judgments are coming in favor of reservation rather than opposing the reservation. So this basically the overall character or overall the judicial nature or the overall character. This we can see the changes from 1950 to 2022, and then maybe 1990 up to Mandal Commission. The case was different after Mandal Commission.
There are nearly 122 amendments, if my memory is correct. So for 75 years.
Yeah. Correct. So basically, these all were fighting not to give representation or not to give the reservation. Means as far as every interpretation, if we see. If we see that it is moving toward that how these people can be kept away from the reservation. Now, if we see the recent developments, it is coming that why we should not give the reservations toward them. So it is entire different perspective that is coming up. So as far as the basic structure you touched, and you already elaborated in the Keshwananda Bharti case, or whatever the judgments are made toward the basic structure of the this reservation and basic structure of the constitution. So how do you see as far as this basic structure of the constitution is considered, and the three organs of the states like legislative, executive, and judicial, how you correlate these organs with this particular judgment, and how they came up? What is your opinion, sir?
Yeah, you rightly touched the point. The more question is the fundamental, as we raised that this this provisions affected the basic structure. That's the point number one. We petitioners made it, and how it is affected. The basic structure, parliamentary democracy, participative democracy, one of the fundamental and essential features of the democracy. But in this 103rd Amendment, the Parliament did not discuss on the features, on the provisions of this 103rd Amendment at all. Let me give you briefly how the legislative process started, how quickly they've gone through the process.
Please, please.
On 8th January 2019, a bill, that is the 124th bill, was introduced in the House of the People. And for the provisions we have already made. On the very next day, 9th January, it was passed by the Lok Sabha. And that is the last day of the winter session of the particular session. We know it very well in our country, the parliamentarians. They rush to their constituencies either last day or even one before that only. So one can imagine what is the reason and purpose behind introducing such august, important, monumental bill on the last day of the session, close to the winter session of the Parliament of the Lok Sabha. This has to be addressed. Number two, then it was passed on 10th January. On the same day, the bill was passed by the Lok Sabha 9th, introduced on 8th, passed by the Lok Sabha on the 9th, and on the very next 10th January, it was tabled in the Rajya Sabha. In the table in the Rajya Sabha also, there were 5 amendments were moved. All amendments are rejected. Second, the DMK MP, Kanimadi, moved a motion supported by left parties to refer the bill to the Parliamentary Standing Committee. Not accepted. Then motion moved, 18 votes in favor of it and 155 against it. One absented it. See the situation, the Parliament, the people. It shows that this many people, that means all the political parties except the DMK and left parties, they wanted this type of reservation should go to the forward community. That is all in a sum and substance. See, what is the Parliament is a duty and responsibility. They vote to the people and the nation. This type of partisan attitude, had they gone into the province, see, they can take any decision, deliberation, yes or no, it is their exclusive right. We are not, but without knowing or without studying or without understanding what is the content of the provision made, this much the parliamentarians have a duty to tell the people or to understand them, to understand it. When it is not at all discussed, what is the meaning of having a parliamentary and participatory democracy? So therefore, the first principle of democracy, the basic structure, that is the democratic form of government, it is one of the basic and fundamental feature of the Constitution, is directly nailed by the parliamentarians of this country by not having discussion on this subject. That is number one. Basics, how the basic structure is violated. Then again, not only that, on 10th judge is tabled in the Rajya Sabha, and the Rajya Sabha, as it is passed by the Lok Sabha, was passed by the Rajya Sabha. That means without making any contribution by way of addition, deletion, or modification. Whether the Parliament needs whether is it the job of the Rajya Sabha not to contribute anything on such a monumental bill? Number three, that shows the political intention will not to grant any, to affect the people of the so-called scheduled caste, scheduled tribe, OBC communities and all, at the same time to favor the other socially and economically advanced position, forward community they wanted to help. As a political system, we have a very, our political system, in my opinion, is not in a very good shape or conditions and all. They are not certainly, in my opinion, working in favor of the marginalized sections of the society, and it is not good for the country for the years to come, months to come, or in the centuries to come. Number 3. And finally, the Rajya Sabha passed it on the same day, and it is sent to the president for assent. The president give the assent on 12th November, and it is notified on the 14th. It is 14th January. The president give the assent on 12th January, and the bill came into force with effect from 14th January 2019. This is a period of 8th January to 14th January, approximately 5 days, which is the shortest period spent by the parliament in passing such a monumental bill. There cannot be better evidence to prove that the parliament and party-based system of democracy was not at all adhered or followed in as far as this introduction of bill is concerned. This is the first murder of democracy, I would like to say. So that means the political parties, they nailed the first nail on this, on the corpus of the democracy is concerned. Coming back to the executive process. Now, how the executive process? It came into force with the 14th January. Then the Department of DOPT, Department of Personnel and Training, on 19th January, after 4 days, 3 days after, the Department of Personnel and Training issued a detailed communication to all the ministries and government departments with the request to provide for 10% reservation to economically weaker sections, civil posts, and administration education institutions. See the gap, how fast they are moving. So there is a nexus between the politicians, the legislature, the executive, hands and gloves. They did their job and they started their job. It's coming like the relay race. First cycle is completed, second cycle is this. On 17th January, MHRD again communicate to all the department, government, ministry and government, including the UGC and all the universities, again the request to implement this reservation. And again on this 18th January, UGC again issued the notification to selected universities for strict implementation. And the DOPT again on 31st January issues the detailed guidelines, operational guidelines for enforcement of this. This is how the executive process. Now let me come to the third one, the judicial process. So first legislative process, first relay race, second executive process, and the third one is judicial process. The third leg I would like to call it as a. Then within the, just very briefly, within a few hours of the bill was passed in the Rajya Sabha, the petition was filed by the NGO, followed by the only party, DMK, they filed a motion in the Madras High Court challenging that this bill is violative of the basic structure of the constitution. The contention is reservation should be based on community to which individuals belong to and not their economic status. This is the plea raised by the DMK government in a motion petition filed before the High Court that reservation should be based on community based only, but not economic status based only. This is one. Then after this, then on 31st July, the then Chief Justice of India declared that refused to pass a stay order on that. Of course, there are the development. Justice Ranjan Gogoi, as he then was, and Justice they refused to stay on this judgment. That means, they should have, in my opinion, when there is such a monumental amendment is challenged, they should have stayed this operation of this amendment. With the result, what has happened? The government started. One is the matter is subjudice, okay, but the court has its own wisdom, right? They can add this. In my opinion, they should have stayed the operation of this. Since they did not stay the operation, now all the departments have already filled the vacancy. Suppose it has no relevance as a this concern because it is upheld with the Supreme Court. Now this is about this concern. Then thereafter, then the bill was everything was bill was taken up for on 6th September. The matter was listed for hearing, and the 8th September the first hearing started. The hearing completed on 27th September, and the Supreme gave the judgment on 7th November 2022. This is what the things concern. So, my conclude. So, this basic structure I approved, established rather than as per myself concern, they violated this basic structure now. Executives also, without waiting for they collided hand with the legislature, they completed their job. And the Supreme Court, by giving their verdict, they have also contributed to the murder of the democracy, perhaps by nailing the third nail, and the coffin is concerned. That this is what, in my opinion, is concerned, and the outcomes are going to be. I also would like to what I visualize as things and all. We are perhaps in the situation of British era. We are taking the U-turn to the British era with the great difficulty, the great effort, great sacrifice of innumerable souls. We traveled we came through all these agonies, particularly this model is SC, ST schedule. These people have undergone hundreds of years of this, suppression, oppression, everything. We now, after this independent with this fought and all, we just started rising at above certain level. Within a 75 years of this, we are taking the U-turn, going back in the not under the regime of the British rulers, but within ourselves, the so-called the higher community or a Brahminical community. They now they are taking the this place of whether it's East India Company or whatever you call it as. Now it is I clearly visible that we have taken a U-turn and we are going back in. It will take another 1,000 years for us again to come like this only. This is what is my individual. I wish I should be wrong.
Right, sir. Sir, basically, as far as this overall development from 8th January, you told to 31st January, if we say practically. So within almost 22 days, all the developments have happened, and right from putting a bill to the implementation of the bill, and that to giving the notification guidelines, everything had happened within a short time of time.
That's yeah. No, I will also add one more thing. It is a clear cut, behind the curtain, highly technical, sophisticated operation planned and executed by all the organs of the state in itself. That is all. Nothing more, nothing less. It is a calculated exercise right from the drafting of the bill onwards. They made a roadmap, how it should be made, how it should be moved, everything. They have been given this thing and all. It is a calculated, pre-planned exercise by all the organs of the state put together. That's it in my. That's
so, sir, basically, this is as far as reservation is concerned, though they are calling it as EWS or whatever may be, but it is a part of reservation. So, reservation for this, basically, whatever development has happened from 8th to 31st. This is one type of reservation, but there is also, as per constitutional provisions, reservations to other sectors. 50% almost reservation is there for other sectors, such as OBC. So, for the last 75 years of existence, do you see any time any such type of step has been taken by the government, or right from the implementation of the reservation is considered, or providing a guidelines is considered, or checking the implementation, whether the percentage that has been given is implemented by the various organs of the democratic society or not? Any evidence you could find for the last 75 years, sir?
No, to the best of knowledge, I have not. But on the contrary, now it has been widely. It's a fact that even if my memory is 77th Amendment, subject to correction, the constitutional amendment made for giving promotion to SC/STs in the promotion level, that is not being implemented for the last 27 years. It was brought to the knowledge of the 5-judge bench. It is being coming very regularly coming in the press. What it is known to the judiciary, and why everybody is quiet? Because nobody is there to speak for this disadvantaged sections of the society. Open secret. 27 years constitutional amendment not implemented. What is the meaning of it? Can the Supreme Court have the power of judicial review? So moto they take all type of matters. Why can't this matter be contempt of court? Why this? See, if there is a will, there is a way. Only thing is there is a lack of will at all the levels of the judiciary, executive, and legislature. That is all. Nothing more, nothing less. We sit. For example, we sit on in the case of your this death penalty and all. We sit now over the night. But one that is okay. Why can't like that? You take such stuff matters on priority matters. Sit 1 or 2 days. Take some decision. There is no meaning in lingering on the issue. Like what is the denomination of 500, 100 notes? What is the use of it having discussion? Everything is over on that matter. Still, the Supreme Court is sitting on it. What for? At whose cost? Where is the, even if they come out, what is the outcome of this this exercise? So we should rise to come to the senses. See, the relevance is important. What is relevant that particular point of time, that is very, very important. Doing the postmortem, we saw that SR Bommai onwards. We are doing the postmortem only. So therefore, the judiciary should rise to the occasions. They should issue the text timely, take the decisions timely. That is what needed. Please.
Correct, sir. So, sir, whatever the judgment has come from the Supreme Court in this month, so how do you see the effect of this particular judgment in coming days or coming generations that could face? How do you foresee, sir, the judgment?
I already told you one more thing I would like to bring it to perhaps it as my escaped awareness. And see, coming back to this, let us take the situation reservation and post reservation period. There is how the reservation worked out. Let us take 100 seats available. If there were 100 seats available out of 200 seats, I'll for the comparison purpose, 200 seats available. Just 1 minute, please. Let me say this reservation status pre-amendment, that is the 14th January, and post-amendment, say, after 14th January. Let us say total number of seats 200. Reservation for SC 30 seats at the rate of 15%. ST 15 seats at the rate of 15%, both pre and post. OBC 27%, which comes to 54, pre and post. Now we have introduced that EWS 10%. In the pre-amendment era, it will not be there. Now, after the amendment, after the post-amendment, 14 January onwards, it will come 20. With the result, the left-out seats available for all, including SC, ST, OBC, that rims about 100 in the pre-amendment era. Out of the 100 seats is available for competition on merit, including by SC, ST, OBC. That is very important, underlining it. Now, what is the effect after the amendment? This kitty of 100 that comes to 80 only. That means the opportunity available for SC, ST, and OBC to fight and compete and come on merit is reduced by 20%. It is because of this. That is the effect of this. Many people are not in a position to study this. Another thing, very, very painful thing. It's a reality. See, it is a system that is the system, how it works. Let me explain it to our viewers. See, if you see the reservation is 15% for SC, 7% for ST. But if you break it up by class 1, class 2, class 3, class 4, it is admitted facts based on evidence. SC, STs are maximum appointed, observed maximum, and the class 4 and class 3. Very few percentage of class 2 and class 1. What is the reason why? Because they what they clear all the merit exam, all the competitive examinations, merit based. They can come up the cutoff points. But at the interview stage, because we have the Article 335, which says that maintenance of efficiency in the administration should be consistently maintained only for SC/STs. That is so they bring that these people, even the clear that made this competitive test, they do not have the competency, no criteria. They reject them outrightly, deliberately. They keep them outside. Then that is what class 1, class 2. Now what happens once they say that they are not eligible, they are not competent, they are efficient, no criteria, no nothing is concerned. So then what the outcome is? So then it becomes a unfilled vacancy. Now the unfilled vacancy, after now these days, it is taken back to the original criteria of the unreserved. So it comes, it's a cycle. So our share, legitimate share of reservation is taken away deliberately to the other pool. So if it is continuous, a day will come, the SC/ST will not have any opportunity. They will not be given any opportunity to occupy the class 1, class 2 positions. And again, I'll come back to the British period. That Sudras, the Varna system. We will be only meant for, this is what the government is proving again and again. You people are meant only for class 3 and class 4 only. This is what the successive governments are proving, beyond doubt. This is what going to happen in the near future. I don't see at all that the people belong to SC/ST OBC community, they will be allowed, even on merit, to occupy this position. This is number one. Now let me remotely connected. Let me also tell our viewers, 75 years gone by, we have now the country has been looted, corruption. Who are indulged in corruptions? Only people in the policy making bodies. Who are the people in position in the policy making? Is it the scheduled caste? Is it a scheduled tribe? Let this agencies know that we have these investigation agencies. Let them come out of it of 75 years about the corruption gone by, or the corrupt practices adopted by over the 70 years based on the data. Control and Auditor General, CAG, he is having the data. Let him come out year-wise, even for the session-wise or the period-wise, 10 decade wise. What is all the public sector undertakings? Whatever I'll let him go to it. Then you come out. How many people are in the class 3 invested with the power to take a decision? Then why can't this? Is it not a fact that all the corruption taking place in the countries are done by the people who belong to the other segment only? Open secret. Nobody's bothered. But only in the name of this or the another thing taken. If not today, the government, successive government answer. If not today, tomorrow they have to answer all these queries and all. That is what another. So sorry, not related to this, but if it's indirectly, it is connected to this issue only. Why people are people are policy making. These are the people who have the power to make the policy, decision makers. They alone commit such mistakes. Unknown mistakes are pardonable, but known mistakes certainly not pardonable. That is what the another issue about this concern. Please.
Correct, sir. Yes, sir. You had elaborated very rightly and aptly within the time allotted, and it was really a very informative session on this particular aspect of what has happened in the entire process of 103rd Amendment, as well as the development that has been happened. Because always, whenever even the judgment has been given and it has to be challenged, then again higher judge bench has to be put, and various other constraints will be there.
I have one more point to add. In fact, if you have time, please. One more. Now, there are possible impact of this amendment. I have two observations. I have two things to say. Now, I referred about the Article 335, maintenance of efficiency in the administration. That is not, as of now, is made necessary for this 10% of the EWS category. So, in my opinion, so with regards to the 10% EWS category, less meritorious, less efficient people are likely to enter into the administrative position in the government. So that is going to affect the efficiency part of it. Number two, again, with now the system has created for obtaining the certificate that EWS, Now it is going to open the Pandora's box, like the past it has happened. People not belong to that categories, falling under the remaining 50% unregistered, they in all probably try to get in one way or the other certificate otherwise also. They will also. That means this 10%, the people themselves only, those meritorious, not efficient, they will come into this way. And the other people by way of other route, by getting this, whatever it is getting certificate is not that difficult in our country's concern. Anybody can get any type of certificate. So this is the way, both ways. On the one side, inefficient Indian people will enter in the system. On the other way, people with the money, power, everything, they will enter the system. And when they join hands, what will happen? It is anybody's guess. This is what the impact that I will also see on the scenes concern. And third one, this decision and the political or a social system is going to completely communal disharmony, which is going to have the secular character of this country. Why they divide? Why you exclude them? Where is the provision, the constitutional framework to divide them, the country into two partition? Are we going to the back to the partition, India, Pakistan partition? Is it necessary now with this stage and all? Why this exclusion? This should not have been done at all. That is what, please.
Right, sir, right. So very, very rightly pointed out, and it is a very informative information that has been shared by you, and definitely our viewers are enlightened, and they had got a first-hand information rightly from a person who was directly involved in the petitioner. All you people had fight for this particular reservations and the rights of the indigenous people, marginalized section of the people. But still the judgment could not be made in favor of this particular basic structure of the constitution. So anyhow, there are ways, and the people will definitely think, the citizens of the country will definitely think on this particular aspect, whatever has been elaborated, and they will have to come back on this particular issue. Already, I think the Kerala government has challenged once again this and filed a plea for this judgment.
Yes, review petition will be filed. Certainly, we will also do in our side also. We will do the best possible on our side.
Sure. So whatever ways are there, that ways will be continued. Democratic ways will be continued in this particular process to get the rights of the marginalized section. Sir, on behalf of MNT News Network, I am really very, very thankful to you for giving your time and the information, first-hand information to our viewers. And it was really a nice interaction with you today. And hope in future also you will associate with us on different aspects related to the this particular session, particular your area of judiciary. We will again invite you, sir. For today, thank you very much for joining today, and thank
Highly
you.
Obliged, sir. Highly obliged, sir. Thank you.
So this was Professor Dr. K. Elumalai, sir, who was directly witnessed for this particular case, and he was involved in this particular case, and all the developments that has happened here pointed out in front of us. So it's the duty of every citizens to give the correct information to the society, to make a correct opinion of the society by giving the right information, what has happened and what can be happened in coming days. So I hope this information will be there in this particular link, and you all viewers will pass on the link to others who are in your network, so that they will also be able to get this particular information and spread this information to others. This is very, very informative information, and hope you all will have a correct path to spread this information. Thank you very much for today for joining MNT News Network, and tomorrow again at 8:30 we will meet with another topic in Hindi at 8:30 p.m. itself. So thank you very much for joining today. Jai Bhim, Jai Mulyavasi, Jai Samvidhan, Jai Bharat.